Business law is far-reaching in effect, vast in its scope, and rightfully it deserves a constant refresher and an update. Business law is quite dynamic with three major components: commercial law, industrial law, and corporate law. We start with corporate law, taking Companies Act and looking into the nature and significance of company and corporate field. I am Vitthal Prabhu, bringing you the weekly video on business law refresher. Hope you will find the video interesting and useful. From a common perspective, company means an association of persons formed for the purpose of carrying on a business. Companies Act 2013 defines a company under section 2 subsection 20. It says a company is one which is incorporated under this act, that is Companies Act 2013, or any previous company law. Incorporation is the legal process of bringing a company into existence. Any previous company law has three components: 1850, 1857 and 1956. 1850 is the first law on registration of joint stock companies. 1857 is first introduction of limited liability. 1956 is the first law after independence, and the current act is Indian Companies Act 2013, which comprehensively covers both listed and unlisted companies across the country. An incorporated company has certain unique features. The first feature is it is a separate legal entity. It's an artificial person existing in the eyes of law and can do everything like a natural person except a few acts like singing, dancing, painting, etc. There is a classic case, Salomon versus Salomon and Company Limited. Salomon converted his business into Salomon and Company, and the company had three components of liabilities: shares held by Salomon, debentures held by Salomon's family, and unsecured creditors. When the company went into liquidation, unsecured creditors wanted to be paid out first, stating Salomon and Company are one and the same. Court disagreed with them and it held company is different from its members. The second unique feature is limited liability. This concept of restricting liability to the extent of nominal value unpaid gave lot of security to investors who wanted to have their private property not exposed to the business risks. And this unique feature helped company to grow up as the most popular organizational structure for business. The third unique feature of a company is perpetual succession. It continues in spite of change in its members. Like a river where the water keeps changing, a river keeps its identity. This was held in Meat Supply Guildford Company case, where all members of a company died in an incident, and the court said life of the company is independent of the life of its members, therefore it keeps continuing. Company can have property in its own name under the feature of separate property. Its properties are not that of the member. In Makaura versus Northern Assurance Company, company's timber was insured by one of the shareholders who held majority of the shares. On the timber being lost, insurance company refused to pay compensation to the member for the simple reason the property was in the name of the company, not in the name of the member, and hence he cannot have an insurable interest. Common seal is the signature of the company. It has to be affixed following the procedure prescribed. That should be a resolution passed by the board or a committee of the board, and the authorized people have to sign off confirming that the stamp was affixed in their presence. Transferability of shares is another unique feature. There are two sections in the Companies Act. Section 44, which says shares or debentures are movable property and they are transferable as per provisions of the articles. But section 58 subsection 2 targets public company and says securities or other interest of any member shall be freely transferable. On the strength of its separate legal entity, a company can sue others and it can also be sued by others. but it has to be represented by a natural person. A suit for damages against defamation could also be filed by a company if any published material affects its business. In all, there are 7 unique features of a company: separate legal entity, limited liability, perpetual succession, separate property, common seal, transferability of shares, and capacity to sue and be sued. The unique feature of separate legal entity gives freedom to the operators of a company, and that freedom is granted to them by the corporate wheel. Who operates behind the wheel is not business of outsiders, but there are cases where the corporate wheel will be pierced, mainly where separate identity is wrongfully used. There are 2 provisions. One, as per the Companies Act, where personal liability of directors and members comes to the fore for reasons of non-compliance of requirements of incorporation, misdescription of name, fraudulent conduct of business, etc. Second, even the courts, in the course of their judicial interpretation, pierce the corporate wheel to find out the real person who is guilty. The first ground where courts lift the corporate wheel is for protection of governmental revenue. Whenever there is a tax evasion, as it happened in case of Dinshaw Manekji Patit, where 4 private companies were used to show personal income as corporate income, the court lifted the wheel and fixed responsibility on the individual who misused the corporate entity. Corporate wheel is pierced in times of war to find out any alien enemy behind a company. It happened in case of Daimler Company Limited during World War I, where the English company had members and directors from Germany. Product was from Germany. When they started realizing debtors, the debtors approached the court, and the court upheld the debtors' claim that they need not have to pay because it will be as good as funding an alien enemy which is against public policy. Where there are apparent acts of fraud or improper conduct, courts always lift the corporate wheel to find out the personality behind the company. Just like in an instance of blacklisting a contractor who submits his bid in the name of a newly formed company, courts will see who is behind the company so that acts of fraud or improper conduct go punished. Where there are acts opposed to public policy, courts prefer to lift the corporate wheel to find out the personalities behind the cloak. Example, to avoid welfare legislations, there is a bad practice of showing the staff strength at a lower level by splitting it between 2 different companies. In such case, the court will find out who are the promoters behind those 2 split companies who can be brought to book. And this is where the corporate wheel is lifted. Any transaction that highlights an attempt to avoid legal obligations, courts prefer to find out who is behind the corporate wheel. It happened in case of Guilford Motor Company Limited, where Horney, a person appointed with an undertaking that he will not entice away the customers and staff of his employer when he leaves service, he forms a separate company, and through that company he violates this condition. Courts ignore the company which he has floated and they identify Horney to be the responsible person by lifting the corporate wheel. Courts invariably go after the persons who are responsible lifting the corporate wheel in cases involving contempt of court. Be it a director, manager, secretary or other officer, he will be proceeded against and punished, disregarding the separate legal entity of the company. Thus, in all, there are 6 instances where corporate wheel will normally be lifted: for protection of revenue, for identifying alien enemy, in cases of fraud or improper conduct, acts opposed to public policy, where intention is to avoid legal obligations, and cases involving contempt of court.